Good morning. We are going to discuss about Bharatiya Nyaya Sanhita. But before that, before starting BNS, we are going to discuss something about IPC because our BNS is based upon our previous IPC only. Many of the definition, many of the concepts, they remain the same. So we have to study about our previous criminal law which was governing us for 161 years and 6 months. So what is criminal law? Criminal law means a law which defines crime and it states about punishment. In an era, you can say, where man was yet not civilized, in an uncivilized era, there was no criminal law as such. At that time, might was right. The weak was succumbed. The weak was controlled by the mighty person. At that time, no criminal law was there. Slowly afterwards, when man got civilized, he started making certain rules and regulations. And while making these rules and regulations, he discussed about certain wrongs for which there should be some kind of punishment because they were severe. Therefore, he started calling it as crime. Crime is an act of commission or omission which has been forbidden by law. In ancient India, we were having some concept of this criminal law, or you can say not some concept, we were having lots of concepts. There were classification of criminals also. In Kautilya's Arthashastra, there are many concepts which we follow today, like where the jail should be constructed, how the jail should be constructed. He was calling them as Bandha Nagaradhyaksha. Bandha means closed. Closed Nagaradhyaksha. Today we call him as a jailer. He is the head of the jail. He governs all of them. So in Kautilya's Arthashastra or Amanusmruti or in Ashruti, Smrutis, Dharma Shastras, Dharma Sutras, there are many concepts which tell about rules and regulations which govern us. The rules are made by whom? The people. For whom? Again, for the people. Because they want a good society. Therefore, concepts of criminal law were present in ancient times. Thereafter, in the Mughal period, they also made certain rules and regulations relating to crime and criminal law. The punishments were very barbaric, strict punishments were there, and a deterrent kind of concept was there mostly in the Mughal period. However, there were certain flaws in the evidence law and also in the type of punishment, like a concept of tazir was there. What is tazir? Tazir means discretionary punishment. Means the judge could give any punishment. Today we don't do that. A judge is also bound by law. A judge cannot go below the minimum. The judge cannot go above the maximum. He is having the discretionary powers in between the minimum and the maximum. But the kind of punishment tazir was complete discretionary powers were given to the judge. Therefore, it was not good. Or the valuation, you can say the value of one man witness was equivalent to 2 women witnesses. This evidence rules was also not proper. Or you can say the concept of had was there. What was had? Fixed punishment. Means though he is a first offender, he'll get that punishment. He is a habitual criminal, he will get that punishment only. Means in certain cases, the judge was not having any kind of discretionary powers. Means either he was having lots of discretionary power or either he was having very strict, means he has to follow the had, that is a limit. He has to give that punishment only. So certain concepts in the Mughal period were not proper. But that Muslim criminal law was governing the whole of India. Thereafter, the Britishers came here, and the Britishers till 1772, they have not done much relating to our legal system. Warren Hastings, he passed the regulating acts of 1772, 1773 and all, and he made here the Adalat system. Mufassil Diwani Adalat, Mufassil Fauzdari Adalat, Sadar Nizamat Adalat, like that Adalat system he brought here. So from 1772, we can say that certain, you can say legal aspects were introduced by the Britishers in India. Thereafter, means after Warren Hastings, Lord Cornwallis came in India and he saw that criminal justice system was not in a proper manner. Therefore, he made certain changes. He introduced the concept of like importance of mens rea. He removed all the flaws which were there in the Muslim criminal system like had, tazir, kisa or dyut. Dyut means what? Blood money. Blood money concept is like the legal representative of the victim, they will decide whether to file a case, whether to continue the case or not. These all concepts were removed by Lord Cornwallis. Therefore, it was called as Cornwallis Code, which he brought. Okay, and thereafter it continued. It was a period of 1790 and all. Thereafter, in 1833, Lord Macaulay came here and he asked for a charter, that is the Charter of 1833, which brought centralization here, that is a parliament came into existence here. He was a law member, and what he stated that we have to make law specifically for India, though it will be based upon English law, but we have to make it for India. And the first law commission was established and he himself was the first chairperson of the first law commission, and he took the work of framing or making of or drafting of the Indian Penal Code. Okay, now it was drafted, it got the assent of the council on 6th October 1860. However, it was enforced from 1st January 1862. I'll repeat again. IPC was enacted on 6th October 1860 and it started its enforcement from 1st January 1862. From 1862, it was continuing for 161 years and 6 months. Certain concepts, really they are good, like the definition of murder, the theft and all. We can't change it. Those are good definitions, proper definition, no flaws are there. So while learning IPC, so many generations have gone through that IPC, generations of advocates have gone through IPC and they considered that it was a good law. It is, you can say basic concepts are there same, they are continuing in BNS. Therefore, it was a good law. However, certain flaws were there in IPC also. Which flaws were there? It became very bulky. 511 sections. With in between we had made many amendments like 120A, 120B, 498A or section 304A, B. Like that many sections were being introduced. So basic sections were 23 chapters and 511 sections, and in between we had added also. So it became very bulky. Small sections, unnecessary, they were separated, like one chapter consisting of many sections, but small aspects were like a separate section. A section defining an offense, a section giving the punishment. Little bit changes, the other section. Little bit changes, the other section. Therefore, IPC became bulky. Many things with the new changes, they were not introduced, which are now introduced in BNS, like snatching. Now, where to keep snatching? That was a question for the police officers before, because snatching was not defined in IPC, or terrorism was not defined in IPC. Many things were not there. One concept called as community service, which has been introduced, though the judges were trying to give this type of community service in many cases, they were giving, but it was not like mentioned in the law. Therefore, there was a need of changing the Indian Penal Code, and it changed with a new name, the Bharatiya Nyaya Sanhita, which was enforced from 1st July 2024. We are going to start with that, and we are going to see section wise. Each and every section we will see, and in between when we discuss BNS, we will compare it with the Indian Penal Code. Like it will not be like I will just discuss about BNS. No, BNS is based upon our IPC. So at a time we are going to compare also. We will see the concept and we will compare our BNS with our Indian Penal Code. Okay. Bye bye. See you in the next video.